Okay, hi, welcome to Ministry Under Fire. I am Bob Tyler, and this is Jennifer Bursch, Netta Higuera. We're all attorneys with Advocates for Faith and Freedom and the law firm of Tyler and Bursch. And we want to welcome all two of you who are watching. Jen's parents, probably about all we have at this point in time. We'll see. This is our first one that we're doing, and our goal is to start bringing information out to our supporters and all of you who are interested, especially to the church, with regard to what's happening in our culture today. This is we started the Ministry Under Fire last year, and we had a conference up at Gateway Seminary, and well-attended conference. Unfortunately, now with COVID-19, those are not permissible in person. So we're going to be recording this live today. We'll actually be doing recordings every Wednesday. The next 3 Wednesdays we'll be addressing various topics for the church and ministries. Everybody can join in on this. This is not limited to only pastors and church leaders, but we're going to be talking today about, I think, something that's going to be of interest to all. We're going to be talking about COVID-19, its impact on religious liberty, our strategy for fighting back, and those issues that we're battling. So first of all, Advocates for Faith and Freedom is a nonprofit organization. We battle for religious liberty. So much here in California, we do elsewhere as well. For example, in New York, we have a case regarding our friend Jim Doman and the Church United. There we're in the Court of Appeal. We're battling censorship by big tech. And so we just recently filed our appellate brief. We're waiting for a hearing in that case. Netta, when do you think we're going to have that hearing?
It's difficult to know. It depends on the court schedule. We just have to wait and see what they decide. Probably
in the next few months.
Hopefully, yeah.
3 to 4 months max, probably. That case is huge because it is going to impact this Communications Decency Act, which President Trump has been targeting, and the Justice Department is investigating. And we just happen to have this, quiet little case that will probably set significant legal precedent for the entire country as it relates to discrimination by social media and whether they have the right to be able to tell Christians or persons even of their sexual orientation, we're not going to serve you because of your faith, or persons because they're black, or whatever the issue is. They have the right presently, it appears, to be able to discriminate. So we're going to be battling against that. We'll talk about that in the future. Today we're talking about COVID-19. And Tyler and Bursch is our private law firm. Jen's my law partner there, and we have a unique specialty, particularly in representing lots of churches, lots of Christian schools, among other business matters. And so let's get into what we're talking about today. So today, I guess there's a big question of why. We've been battling for churches. We've been battling for Christian schools and fighting back against COVID-19. And so there's this, I think, a question even within the church as to why should we be doing this? Jen, what is from your perspective, what do you see as the reason? Why should we be doing this?
I think that it's changed over time. I actually was reading a Supreme Court case that came out just last month on COVID and within the last month. And I think Justice Kavanaugh said it pretty well when he said, as things have changed, it's important to stand up. As we get more scientific information about what's going on with COVID and better numbers and better science that's been done, we just need to expect our government to create laws that make sense and protect our constitutional liberties. And I think we're at that point that we have more information and we should expect that. And we just need to defend our constitutional rights. And that's really what we're doing in all of these cases.
Now, how about yourself?
My why is really the next generation, because I don't want my daughter and my son to grow up in a country where the government can close churches for months at a time and disallow indoor worship service and ban worship singing, which has been part of the church for 2,000 years. We've sang worship during our church services. So that is the why for me.
You know, and behind all of that is the fact that a lot of new data is coming out. Mm-hmm. And was it just last week, I think, that the CDC announced that, you know, here, I just heard this morning on AP News, 100 and I think it was 80 some thousand people have died because of COVID-19. Mm-hmm. But that's not accurate. There is, according to the CDC, only 94% of the people who have died, 94% of the people who have died actually had comorbidities, and many, if not all of them, actually died from something else. They just happened to have COVID-19. Therefore, only 6% of the people who are there claiming actually died from COVID-19. And this is information that's coming out that I think is important for us to get out. That's kind of behind our why. We look at it and say it's no longer really rational to be censoring and closing down churches like they have been. Here's a great verse. A friend of mine here in our office, Nick Kosis, came over and he said, "Bob, I was just listening. Here's a scripture that I heard this morning, and I put it in here because I think it's really relevant." Jesus in the synagogue, in Luke 4:18, he says, "The Spirit of the Lord is upon me, because he has anointed me to preach the gospel to the poor. He has sent me to heal the brokenhearted, to proclaim liberty to the captives, and recovery of sight to the blind, to set at liberty those who are oppressed." And, you know, that's what Jesus says. This is why I'm here. And in the beginning of all this, going back into April, the shutdown had been ongoing for about a month and a half, and pastors who we were meeting with were already experiencing this incredible mental and spiritual oppression that had been going on. People who suicide was becoming significant. We had lots of mental distress, and they were talking about the people who they were caring for in their own congregation. And so, you know, they began saying there's not only is there this COVID epidemic, but there's a spiritual and mental health epidemic. So that's huge, and that's a really big issue now. And even the director of the CDC said, hey, we've got to start thinking about the fact that there are more people dying of suicide than actually dying from COVID-19. So with these issues, we feel it's really important to help the church and support the church to get back open and to be able to support the needs of those people. I know myself, you know, I want to get back indoors. It was 100 and some degrees. We're in Marietta, and it was over 100 degrees last Sunday.
Right.
You know, and they're telling, you know, people that, oh, well, you can meet outdoors. Okay, let's talk about, generally we're going to be talking about our strategy to win in the courts. One, we're going to be talking about how we're challenging the underlying authority of the governor under the Emergency Services Act. We're going to talk about our litigation and the health orders as it relates to schools, as it relates to churches. And I want to get into a little bit, if we have time, to the failure of the U.S. Supreme Court and the Ninth Circuit to address this issue from a real constitutional perspective. Let's first get to our public and private schools. And so let's go, Jen, first. Explain what we're doing presently and on behalf of schools in the California Supreme Court.
Well, we filed a writ in the first instance, which is an emergency writ asking the California Supreme Court, to take a case that really is defending the constitutional rights of public schools and private schools. So we filed two of them. One is on behalf of the Orange County Board of Education and some individual plaintiffs in a charter school in Orange County, really addressing whether it's an equal protection violation. We believe it is, the governor's current mandates on public schools, and just requiring the distance learning through, well, now it's the tiers, but back then it was the watch list. Of course, he changed that. recently. But so we have that lawsuit that we filed, and then we also filed one on behalf of private schools, and that's just 7 private schools throughout the state, really, that are currently being, again, mandated to do distance learning. And, with private schools, it's just such a unique issue because it really, parents are pulling their kids out because if they're going to have to distance learn from home, the financial ramifications on the private schools is just incredibly significant and harmful. And on the public school side, you have disadvantaged, economically disadvantaged families that can't afford to do pandemic pods or set up some type of other learning. And the digital divide is huge in relation to who has adequate internet and who has devices to even be able to do that. We're just seeing so much of an impact on kids and their educational rights, which under the California Constitution are fundamental. So we filed and asked the court to step in and defend those fundamental rights on behalf of the school children all throughout California, whether public or private.
So the concept behind the Equal Protection Clause in the California Constitution is the fact that it says basically all children are entitled to an equal education. And right now we know not all children are getting an equal education. We know that the poor, the special needs, the children of single parent families, the children of families who don't speak English as their first language, they are not getting the same education as the others when they're doing it online, especially the poor, when they don't even have, in some cases, the technology. And there was this picture that went around on Instagram last week of these 2 little girls sitting outside of a Taco Bell up in Central California who are trying to get internet access so they can do their schooling. And it's just very sad. And as Christians, so often people look at us and say, well, you guys are just conservative, Christian, radical, right, Republican, or whatever they might want to call us. You don't care about people who don't have these kinds of needs. Netta, what are your thoughts to that? I mean, how do you respond to that?
Yeah, I think, it's heartbreaking to see what's going on, not just with our students, but our teachers too, and them trying to do the best they can. And, one of the people that signed a declaration is a special needs PE teacher. And can you imagine teaching PE to special needs through a camera? And especially with young children that don't have that attention span. And it's just so tough to see teachers struggling, and then parents adding on top of that, parents having to manage all of this, and the students themselves. You're talking about as young as kindergarten having to sit in front of a computer screen for long periods of time, and the risk is not there to children. You see the statistics, and it just does not justify completely closing down schools whatsoever.
And the CDC agrees with that. So does the American Association of Pediatrics. They've both come out with studies, and we cited all that in our Supreme Court briefs. But there's so many different entities that are saying the harm to school children, whether public or private, and really the financial harm to the private schools is so intense that there's just no justification at this point. They're advocating that kids go back to school. And yet the governor has really increased the amount of time that kids will be out of school with this new tier system that came out after we filed the lawsuit. He keeps moving the ball.
And in our brief, we included numerous expert witnesses. We have an epidemiologist from Stanford, Mr. Kaufman, another expert on public health, and we've got psychologists, a school psychologist. What other experts did we have? We had quite a bit that we put in front of the California Supreme Court for them to review and determine. Now, let's talk about the governor's response, because the California Supreme Court ordered them to file an opposition. Now, explain the governor's response.
To me, the governor's response is you could say it in one sentence, which is there's a pandemic, so we can do what we want. That's really the tone of the brief, is look at given what's happening. But what's interesting is that he didn't actually address any of those experts. The Attorney General didn't address any of those experts or any of the scientific data or any of the actual numbers. They just are relying on this is what's happening. And that's where I pulled this brief from this quote from Justice Kavanaugh, and he says, "But a public health emergency does not give governors and other public health officials carte blanche to disregard the Constitution for as long as the medical problem persists. As more medical and scientific evidence becomes available and the states have time to craft policies in light of that evidence, courts should expect policies that more carefully account for constitutional rights." And that's really what we're asking the Supreme Court to the California Supreme Court to get involved in. I think Kavanaugh's right. I think Justice Kavanaugh is right. I think that we need to look at all the new data that has come out and evaluate that in light of the severe harm that's being done on the other side and make the best decisions we can as a society.
So explain what happened here. This was Justice Kavanaugh's dissent.
Yeah.
This is not the court's majority ruling. This is a dissent that was filed by Justice Kavanaugh. What explain that and why it is not law?
So this is the case that at Calvary Chapel in Nevada filed a lawsuit arguing that they should be able to have 50% capacity because casinos have 50% capacity because, that's how Nevada tourism is really run. So they're allowing casinos to have 50%. The church tried to file what we call a preliminary injunction in order to get an injunction allowing them to do the same thing as casinos, which is really the bread and butter of free exercise clause, that the churches are allowed to at the very least do exactly what other similarly situated entities are doing, and that the law needs to be neutral and generally applicable. And Kavanaugh, the U.S. Supreme Court refused to take the case and consider the preliminary injunction. But Kavanaugh wrote a great dissent, and this is part of his dissent.
It was a 5-4 majority with Justice Roberts siding with the liberal side of the court, saying, "I'm not going to take this case."
Yeah.
I have a theory on why Justice Roberts did not go along with us. But what are your thoughts, Netta, first?
Well, this was the second time that he did that, and he sided with the liberals on the court. The first was South Bay Pentecostal in San Diego, and Roberts actually wrote a concurring opinion, not giving churches the same rights as secular businesses. So then when he did this the second time, I thought he tipped his hand. He showed how he would rule if we had a whole case on the merits and we had discovery and it wasn't just at the preliminary injunction stage. So I don't have a lot of hope in Roberts coming around to our side because he's done this twice, and it was astonishing, especially with the casinos and the restaurants and the gym that are open to 50% capacity in that Nevada case. Yeah, and I mean that was a clear case that we should have won. And Roberts should have been on our side. And
we clearly, the precedent of case law is clearly on our side. Jen, what are your thoughts? What do you think Roberts, what's going on in his head?
I have a hard time reading the Roberts tea leaves these days. I don't understand a lot of his decisions. He seems to, just from an intellectual perspective, I can't follow. I think it's possible he's waiting for more to come out, but to me it's shocking. And Netta, when we were talking about this last night, you had mentioned, and I agree with you, there's enough. It has to be general and neutral and generally applicable. That's what the law is. There's a clear standard, and with casinos being able to be 50%, and that's Kavanaugh. I wish we could read all of Justice Kavanaugh's dissent. It was awesome that he just laid out, hey, why can casinos open at 50%? That's about finances. It's about money. That can't be about a pandemic, because if you can allow 50% of casinos that are honestly much larger, so you're talking about way more significant numbers than you are, the church in Dayton Valley, they went through the numbers. Very small. It's a relatively small church. You're not 50% capacity. It's just not, and they were willing to do all the other things. They're willing to social distance. They're willing to not have families sit in pews 6 feet away from each other and not pass things like communion in between the pews. They were willing to disinfect after every service and make sure that there was egress and ingress that was specific. Kavanaugh went through all that in the dissent and then addressed how casinos are being treated differently. There's just no justification, and I can't even explain Roberts' justification for that, honestly. I just don't agree with it. I think so wholeheartedly that it's hard to understand where he came from on that one.
So for me, the optimistic side, I'll give you a little optimism, is that, I think Justice Roberts, he's one of those types that it seems as though in most instances, anytime there's an opportunity for him to not rule on a case at the Supreme Court, he's not going to. And he is, when these cases went up, they went up on temporary restraining orders, which means that neither the plaintiff nor the defendant, neither the church nor the state have had much opportunity to really engage in significant discovery, in going through and asking the questions of each other and recovering documents, things of that nature. And I'm hopeful that the reason why Roberts in the Nevada case did not agree to take the case up is because he wants more to be fleshed out down below in the record. And he's probably thinking, well, I'm a little worried because this is COVID-19, this is an epidemic. I don't want to be wrong, so let me just wait. And then once COVID-19's over, then I'll defend religious liberties. I'm hoping that that's at least what it is. That's not good, but at least maybe that's what it is. At the same time, though, I think this just goes to show how important this next election is. Because, we're, at this point in time, we have thought, okay, we have a 5-4 majority of conservatives who are going to uphold religious liberty, who are going to uphold the First Amendment. We don't have that. I mean, we have it's 4-4 with a flip-flop. And we had that all through the 80s and 90s.
With Kennedy, yeah.
With Kennedy, and prior to that, Justice O'Connor. And now it seems as though Roberts, the swing vote, and so it's concerning. So this next election is incredibly important. But that's in the federal courts. Explain, Netta, let's give you the first shot at this one. Explain, why are we not taking this case for the schools, for public and private schools? Why aren't we going to the federal courts and arguing on behalf of private Christian schools the free exercise clause? Why aren't we taking this on behalf of schools and arguing the equal protection clause in front of a federal judge in California? What are your thoughts?
Well, we've seen through multiple cases of our own and other religious liberty law firms that federal courts have just shut us down. They haven't wanted to rule in our favor. They've just wanted to avoid the issues altogether. And this is countless. I would say at least 5 federal cases in different districts with different judges. And it's the same thing.
In California.
Right. Yeah, in California federal court. And then at the Ninth Circuit too. The Ninth Circuit has shut us down multiple times. And so it just, it was a dead end, basically, that we weren't getting anywhere. They weren't looking at the legal issues and considering it with honest intellect. It was just deference to the governor. And, again, as Jen said, with the what the governor's response was in the school briefcase. Well, it's a pandemic. We can do whatever we want. And the federal courts have said, yeah, it's a pandemic and we need to defer to our government. So we needed a different strategy. We can't keep doing the same thing and losing. We want to be creative and be flexible and do the best we can.
So the federal courts at this point in time, because of this pandemic, have almost ignored the First Amendment, have almost ignored precedent. And that is dangerous. That's very disturbing. And so that's the same thing in the Ninth Circuit, in the lower courts. Now, early in this pandemic, there were some actually courageous federal judges who I believe were intellectually honest. Mm-hmm. Not here, not on the West Coast, but in the Midwest and in New York, who did give more favorable rulings. But, we live on this side of the Iron Curtain, and we've got a lot of battling to do. Jen, with regard to the issue, we're going to state court because we might have a shot. The California Constitution actually has a provision for free exercise, for equal protection, and those provisions are actually said to be stronger than even the provisions on the federal level. Yeah. So talk about what we're doing in the state court system with regard to this case, challenging constitutionality, et cetera, and kind of our strategy for what you and I have been talking about for a long time.
mean, our goal is just to challenge as much as we can through the state constitution, whether it's private schools, churches, addressing the constitutionality of the Emergency Services Act, which is the governor's underlying ability to do what he's doing, challenging that it's arbitrary and capricious, challenging the Equal Protection Clause, free exercise. It really runs the gamut depending on what the case is and who the client is and what's going on. And we're filing a lot of cross complaints. Obviously, we have a lot of clients that the county is actually filing against them to try to force them to shut down or force them to comply, and that's putting us in a position that we're filing cross complaints.
So the Emergency Services Act is the statute in California that gives the governor what I'm trying to coin. I want people to hear this: arbitrary and unbridled discretion with unending authority. That is what we have in California, and that's the way the statute's written. The statute gives the governor the authority to actually order that statutes be waived, that they be suspended. So one of the things that he's done is each local health official's decision is supposed to be approved and reviewed every 30 days by the local boards of supervisors in each county. And he suspended that statute so that the boards of supervisors are not reviewing the decisions of the local health officers, making it really, that's a due process violation. And what the legislature's done is given the Governor Newsom this, again, arbitrary and unbridled discretion with indefinite authority.
And I think it's important to address some of that arbitrary discretion, and that's, I'm watching the comments that everybody is making online, and I think that there are specific instances that we can point to and say that is incredibly arbitrary. You look at that with schools. Schools are required to do distance learning in all these different situations, but after the governor did that, they issued what they called cohorting guidance. So at this point in California, if you don't have a waiver, or even if you have a waiver for the older grades past 6th grade, because you can get a waiver for K through 6 in certain counties and certain situations, complicated scheme, right? But once you get past that, or regardless of that, you're allowed to have a cohort of 14 kids in a classroom being supervised. So you can facilitate distance learning with the teacher, but the teacher can't actually teach. So we know schools that they're facilitating distance learning across the hall, and just literally across the hall from where a 1st grader, I have a daughter in 1st grade, and she's been across the hall having an iPad all day long, unable to do reading groups, unable to really get an education like she's supposed to. She's 6. She can't even work the iPad really. And across the hall from her is her actual teacher speaking into Google Classrooms, even though she's in a classroom with 14 other kids. For some reason, he's created these guidelines that allow her to be in a classroom with supervision with a teacher, but not actually teaching her. But across the hall, the teacher can do Google Classrooms. That is the definition of arbitrary. Yeah. It can't be science, because why can 14 kids be in a class being supervised but not being taught?
Right.
It just really makes no sense.
They could be babysat too. You put them in a daycare.
Sure.
You put them in a daycare, you can have the adults with the kids and it's fine, but you can't teach them. God forbid you give them, read to them or teach them mathematics.
You can send it to day camps, you can send it, there's all kinds of things you can do, but you can't, those same 14 kids can't be in a classroom. It just makes no sense.
And not only is it arbitrary, but it's irrational. Right? Irrational. I mean, that's one of the tests the Supreme Court will look to, is saying, is there even a rational basis? And we've made the argument there's not even a rational basis for a lot of these orders, particularly as it relates to schools. And we're still talking about schools right now, really. Yeah. And so, hey, let's talk about one other thing. Let's talk about, I want to give some people hope. Why is it so relevant that the California Supreme Court took up our case, ordered the governor to file an opposition?
It's just rare, right? I mean, it's an emergency petition, so often the court will just summarily deny it and not even force the government to respond. And here,
far more often than they ever accept it. I mean, it's an extremely rare circumstance. The court has to look at it and see that it's a matter of significant importance and urgent in nature.
Yeah, and they require them to respond, and not only to respond, but they required them to respond within 4 days, and then they gave us 4 days to respond with a reply brief, which we did last Tuesday. Now we're just waiting for the court to tell us what comes next and wait.
So we're just waiting right now, really, somewhat on pins and needles, because the decision could come out while we're on this chat right now. We're hoping that what's going to happen is the California Supreme Court is going to come back, rule in our favor, and say that it is the order preventing schools from meeting in person is unconstitutional. There's also some significant issues that are kind of in the background, and that's unions. The unions have had a big impact on this. Netta, did you take a look at what the LA Unified Teachers Union had to say about this?
No. What did they have to say?
Well, okay, I thought you did. That was a cue, and I'm sorry, I'm putting you on the spot. But what they said is one of the things that they want to defund police in order for them to go back to work.
Right. Yeah.
And so a lot of the teachers unions, it's not the teachers at the local level who are the ones who are upset and saying, I don't want to go to work. What I'm finding and talking to people, it's the unions that are really preventing this. The union bosses, the union leaders. The California Teachers Association is one of the most significant, powerful unions in the state of California. So we got to pray against that. Now, what do you think is going to happen? Should the California Supreme Court rule in our favor? What kind of impact do you think that might have on the rest of the state as it relates to reopening or even the country?
Oh, it's going to have a significant impact, because it's no longer going to be the governor has full authority to close down whatever he wants and full discretion, no matter what the data says, what experts say. And so that will be the turning of the tide that we really need. So God willing, we will see some good news, because we can't keep going like this. It's been 6 months with the governor constantly moving the ball, with the governor not relying on scientific data, even though he says in his press conference that we're following the science. We're following the science as we, move to these colorful tiers, 4-tiered systems, and move from stages. And it's not like you said, it's the unions, really. It's not a rational basis. It's arbitrary, and the decisions behind it are the power and the unions. And so we really need a victory. We can't just keep going like this. It's tyranny. We're living under tyranny.
I think it's going to have a huge impact. I really think that should we win, it's been said, what happens in California gets exported to the rest of the country. Well, at least I've said that. And so I think a lot of people agree with that. That started back, really, frankly, in the same-sex marriage era. Yeah. I think it's relevant. Jen, do you remember the last time we took something to the California Supreme Court like this?
Yeah. The last time we did it was when Governor Newsom, who was then the mayor of San Francisco, was issuing marriage licenses in violation of state law to same-sex couples. And the Supreme Court ruled in our favor. Yeah, the Supreme Court, we filed this emergency writ directly in the California Supreme Court because we weren't getting anywhere in the lower courts in San Francisco. This was a state law issue. We're in front of these state judges in the county of San Francisco and beating our head up against the wall. And late one night, in a strategy session with some lawyers, we came up with the concept, say, hey, let's just go straight to the California Supreme Court, because there's this very unique procedure that, frankly, most lawyers don't even know about, and it's a provision that is in the Constitution that allows you to file a case directly in the California Supreme Court, skipping the lower courts. We did it against then Mayor Gavin Newsom, and we beat him. Lord, let us win again against, this time, Governor Newsom. Wouldn't that be amazing? Let's talk about some more good news. Jen, there's a school that you've been working hard on, Emmanuel Schools, up in Fresno County. And so, there's some schools who have said, we're not going to just sit back and sit under this tyranny indefinitely. And what did they do? Well, they opened their school. I wish everybody out there and everybody even in this office, all of our staff could meet these clients. They are awesome. Just great, I think, leaders. They've stood up in a respectful way, the financial impact on their school and really the impact on their kids. Ryan Wood, who is their superintendent, has become a good friend, and he is just really passionate about it. He's passionate about the impact that it's having on their kids not to be in school, so they decided to open. And
In-person classes.
Yeah, they're in
On
person.
campus.
They've been there the entire time since mid-August. And they opened for the first week. Nothing really happened. And then the county of Fresno filed a lawsuit against them and sought a temporary restraining order to force them to shut their doors and to do distance learning. And we argued against that, and we won. The judge did not grant the TRO and set it for a preliminary injunction hearing on September 15th.
And this is just after we had filed the case, the private schools case in the California Supreme Court, along with the public schools case in the California Supreme Court. And Emmanuel Schools is the lead plaintiff
Yes.
in that case. And so when the county came against the school and filed this lawsuit in the lower court, one of your defenses was, we're in the California Supreme Court right now, and the California Supreme Court just ordered the governor to respond to why we believe that his actions of keeping schools closed for in-person learning is unconstitutional, and the governor has to respond. And what did the judge have to say to that?
Well, he just said he didn't respond directly to that one issue, but I did argue that, and he did say that he just felt like the county hadn't shown their burden, that it was an emergency such that something had to be done right at that moment. And I don't think they did. At the end of the day, they would have to show that something is going to change. By the time we had that hearing, Emmanuel had been open for 12 days, and that's one of the other things I argued. The school has been open for 12 days, and nothing tragic has occurred. The only thing that's occurred is great education for 600 kids in the Fresno area. And there's no reason to shut them down now when there's been no negative ramifications. And Emmanuel is in a unique situation, and we talked about this in all our briefing. They actually, one of the parents at Emmanuel did an antibody study, and
He's a pathologist.
He's a pathologist. He owns a couple pathology labs, and it's his expertise. And he felt like he had COVID, and his family had COVID back in February. And they decided to test the Emmanuel community. So they tested 200. Drew blood, registered nurse, did it all the right way, followed all the guidelines that they're supposed to follow, and he has established that Emmanuel actually has herd immunity, 59%, using a standard higher than the commercial testing that's being done on antibodies. The 59% of the Emmanuel community has already has the antibodies for COVID-19. So the chance, he basically says the chances it would spread as a super spreader event through Emmanuel is very unlikely. And he honestly believes that that's true of other communities, and that we just don't know it, because COVID was spreading before we were testing for it, and that's where you get back to the science. And we submitted all that to the California Supreme Court. We submitted it to the Superior Court when the county sued Emmanuel. And it's just that's been an interesting conversation too. You talk about the science and how important that is, and the county really is just trying to ignore all that data. And by the way, one last interesting note on that: the doctor has over and over offered those blood samples to the county and to the state to do their own testing to determine whether Emmanuel has herd immunity. Nobody's taking him up on it, but he's offered. He still has it all. And every time someone challenges, he says, "Hey, do it yourself. Go ahead and take it."
Yeah.
Nobody's taking him up on that, though.
One of the great things about that case too is this. So what happens when Emmanuel filed this temporary restraining order? They'll file it, and they basically will set a hearing for the following. They notify us one day, and the following morning, typically at 8 in the morning or 8:30, there'll be a hearing on a restraining order where the county is saying, Judge, they have to be shut down. You have to enter an order restraining them to prevent them from operating. But because we've been in preparation and we have all of these expert witnesses that we've been working on for putting hundreds of pages together of evidence and experts, and our briefing that we did, when they filed this temporary restraining order against Emmanuel, we were able to have a document, an opposition, and also because we'd also filed oppositions to a restraining order in another case, we were ready for it. And
imagine their surprise when they're like, "Oh, we're going to take them by shock, and we're going to file this, and there's a hearing tomorrow. We're going to win." And then we come back with all of the scientific data, with the studies, and to back it up. And I mean, that's amazing.
So we filed in opposition to their very short brief saying, there's an emergency, there's an epidemic, we have authority, they're violating the order, shut them down, in a very short brief with little or no evidence. And then we turn around and, according to the opposing attorney, said we dock dumped them because we turned in within less than 24 hours quite a few hundred pages, I'm assuming. I have not added them up, but quite a few hundred pages of briefing, declarations from our experts, top experts, and the actual evidence that backs them up. And so that was pretty huge.
Yeah, county counsel even commented on it in the hearing, how many documents. He didn't use the words dock dump in the hearing, but he did say, look at how much they filed. And we were prepared. We were ready to go. I mean, to the extent we did dump a bunch of documents on them that morning, but we had been preparing, like you said, and it was important to me just knowing what Emmanuel has gone through and how they're standing up to get the best opposition we could possibly file, and we were able to do that.
Okay, so let's jump to what happened in the writ. So they file a writ, kind of like we filed a writ to the California Supreme Court, an emergency writ. They did the same. The county of Fresno filed an emergency writ to the Court of Appeal to try to overturn the denial of the temporary restraining order. And what happened?
The Court of Appeals denied that yesterday. So yesterday we found out that they denied it, and Emmanuel will at this point be able to stay open until September 15th, absent further issues.
So this is huge, as some would say. Huge. Really, it's a huge victory. Frankly, in California, this is there have been some good things that happened in the John MacArthur case, the Grace community. And our friends over there with Chuck Lamandry and Thomas More Society doing a fine job over there in the briefing, and we're working with each other very well. But this is the first outright done denial. There's no restraining order that we're going to issue. This is actually the first incredible victory in the state of California, in my opinion. There's some good. The next one that comes close, I think, is the John MacArthur case. But in that case, the court still has the ability, or I should say the county still has the ability to go in and make efforts to shut them down, actually go into the church. So that's unfortunate. But we're going to keep plugging away brick by brick and build a wall so we can win. So anyways, that was a fine job. Folks, please be praying for us in the schools cases, in that Emmanuel case. We have, we're representing the Orange County Board of Education as well on the public school side. A conservative majority there allowed us to bring this case on their behalf. They voted and asked us to take this on. So please pray for them. Pray that we get the public schools, the private schools reopened, because that's going to have I think it's going to be somewhat of a landslide effect going forward, or maybe a snowball effect is a better word. Okay, let's jump down. Let's talk about church cases. So, first of all, the question is, where's the First Amendment play into this? We kind of talked about it already. I'm going to kind of leave that to, we talked about before how the federal courts are really not jumping in and using the First Amendment to protect us. It's very concerning. There's a question of whether the free exercise clause really has any teeth any longer as it relates to COVID-19. In the Ninth Circuit, I hate to say it, but the First Amendment has hardly any teeth. I mean, if anything, they've been, filed down, so it's not sharp anymore. We talked about the U.S. Supreme Court ruling already in the Nevada case, and that was a church case, and then there was the South Bay Pentecostal case that came up early. We were actually in the Ninth Circuit on one of our cases, and South Bay Pentecostal case, our friends, again, Chuck Lamandry, they filed this case, and they went to the U.S. Supreme Court. Their case was decided before ours. They went up, And again, Supreme Court denied review on this issue, which was very disturbing. Now, one of the things that we did, we went back and we launched the Declaration of Essentiality. A lot of people might not remember this, but that was, we had about 1,500 pastors who signed and said, we are going to open. We are going to open our church on May 31st, the day of Pentecost. We got together and helped launch this effort with our friends at Church United, with Pastor Jack Hibbs, and Calvary Chapel, Chino Hills, with a number of other pastors. It was pretty incredible. Some big churches here in the Inland Empire, and we went forward and we pushed that. Some of the pastors who we got to meet, Diego Mesa, Pastor Danny up at Fountain of Life, great pastors, great leaders, and so it's encouraging to see some pastors who are really stepping up and saying, we're going to take a lead on this, and we're not going to back down. So they opened, and they said, we're opening on May 31st. What did the governor do? Just before that, he issued some guidelines saying, well, churches can open, but you have to be limited to 100 people indoors, or 25% of your occupancy.
Whichever is less.
Yeah. And so presently, for the very few counties where churches can meet indoors, that's still the order, right, Netta?
Right.
Okay. Now,
No, that's not the order. They have to be outside now.
well, what I said for the ones who, for the few counties that are allowed to meet up in Northern
In
California.
orange. Yeah.
Yeah,
the orange tier now that there's
Yeah.
tiers.
Yeah.
Yeah. Right.
So
And that's if the county allows them, though. So the county can still, if you're in orange tier, the state will allow you to meet indoors at limited capacity, but the county can still say no.
Yeah.
Just like Santa Clara, they're not allowed, but the county has more just tyrannical restrictions than the state.
So, for all of the counties in California, they're not allowed to meet indoors.
Right.
They have to meet outside.
They're in the
Yeah.
purple tier.
Yeah. So,
And they're going to be there for a while.
Yeah.
and so that's what we're dealing with. Let's jump to the case that so many people have heard about, seen it on the news. Pastor Rob McCoy, Calvary Chapel, Godspeak.
Yeah.
So they're meeting indoors, and the sheriff and the district attorney said, we're not going to do anything about it. They've been meeting indoors since before the day of Pentecost. They were meeting, they were doing social distancing, they were doing everything, and Pastor Rob is so committed and is willing to stand up, and they've been studying. One of the things that we did in our briefing in that case, we pointed out that for anybody in Ventura County, which is where they're located, who is healthy and doesn't have underlying health conditions that would be a comorbidity, the chance, even if they get COVID, even if they contract COVID, if they're under 65 years old and have no comorbidities, the chance of them actually dying from COVID-19 is 0.0049%. It's a fraction of a percent. And we were able to point that out. And those are the kinds of things that Pastor Rob McCoy knows. And so they sent code enforcement out. Netta, you worked on a brief for us to battle against their emergency restraining order.
Yes, and they did the same thing with the schools. They filed a complaint and a restraining order, and then the next day there was a court hearing. And thankfully we had some research and we were able to put together a quick response. And the county of Ventura asked the judge to basically physically shut down the church, to have a sheriff board off the doors and physically shut down the church. And ultimately we consider it a victory because Pastor Rob is still able to have services, but he was fined a small fine. So he currently has a $3,000 fine, but praise the Lord, they can still carry on with their services. There aren't armed guards at the door, which is what the county wanted.
So let's talk about what happened there. So the first judge grants a restraining order in favor of the county to order the church to shut down. And Pastor Rob said, and his board, they said, no, we're not going to do that. Kind of like, I think it was Paul and Silas, who the angel came, let them out of jail, and they went straight back into Solomon's portico and continued teaching and speaking and preaching. And so the church said, and Pastor Rob, we're going to teach, even though the judge has ordered a restraining order. And then what happened is they came back and filed for contempt charges. The county asked for contempt charges. What comes with contempt? You can either go to jail, $1,000 fine, and Pastor Rob says, I'll face the consequences if that's what it takes. And he and I had been talking about it a long time. We're saying at some point in time, we're thinking some pastor's probably going to go to jail over this. And Rob said, well, if it is me, then it's me. But he wasn't looking for this fight. He was meeting quietly. Frankly, there are some pastors out there who would love to be the ones that are in the spotlight that gets put in jail. This was not Pastor Rob. Now, so there were the contempt proceedings. One of the things that we came up with in the contempt proceedings was the incredible hypocrisy.
Yes.
So they had the two
county officials surveilling the church in the parking lot, and the county officials were taking down notes, reported to the court that people were close together, that they didn't have masks on, they were not social distancing. Yet here you have two county officials from separate households in the same car without masks,
shoulder to shoulder,
and they're sitting in a church parking lot, surveilling the parking lot. And I mean, and thankfully we had congregants take pictures of them to show as they're on the stand. And Bob, you did an amazing job as these county officials are on the stand talking about how terrible these church goers are behaving and they're not wearing masks. But Bob was able to call them out and say, well, you were in the car next to someone, weren't you? Was that person from your household? Were you wearing a mask? And they were in the car for like 6 hours, was it?
Yeah. And
so it clearly displayed the different rules for different people. Just like Nancy Pelosi can go to a salon.
I was just going to say that.
I mean, it's over and over we're seeing the same thing.
So we had the pictures, and I had one guy, and I said, of course you were wearing your mask, weren't you? And he said, oh yeah, of course I was. And then I hand him a picture, and I say, who's that? And he's looks at it's me. I said, you're not wearing a mask, are you? No. We just caught them in their lie. Now that, in reality, that was not about necessarily just trying to get Pastor Rob and the church out of contempt charges. What it was we intended to do was to show the hypocrisy. There was lots of media in the courtroom. Did they report on that? No. They didn't talk about the fact that what we were able to show how hypocritical this was. Yet they didn't report on it. And so there's another video that we have on YouTube, under Advocates for Faith and Freedom. Go to that, and it's about that exactly. I show the pictures, I lay it out. Please go look at that and show that. We would greatly appreciate it, because that just shows the hypocrisy, and it's coming out more and more as this goes on. So we have other aspects of how we see cases that are coming against churches. Cease and desist letters. I'll run down this list of some that you guys tell me if there's some that I missed. Calvary Chapel Downey, Calvary Chapel San Jose, Cornerstone with Pastor Jim Franklin in Fresno, Awakened Church of San Diego, Grace Community Church John MacArthur. There's a wonderful rabbi who we represent. The ministry, the synagogue is known as Near Simcha. Rabbi Michael Barclay. Wonderful guy, wonderful people, and they're all receiving cease and desist letters, phone calls saying you better stop, you shouldn't be opening.
Fines. You have Calvary Chapel San Jose at about $82,000 in fines right now. Every day it's $5,000. Every day that Calvary Chapel San Jose does not comply with the county's orders, they're getting charged $5,000 a day. And we have another brave pastor, just like Rob McCoy. This is Pastor Mike McClure, who isn't backing down from that whatsoever.
Yeah, and this week we're in process of preparing a lawsuit challenging what occurred and what is occurring there as to Calvary Chapel San Jose, Pastor Mike McClure. Another lawsuit, one of the things we're challenging are these fines, saying it violates the 8th Amendment. One of our attorneys came forward with this idea and say, let's go after these as being unconstitutionally punitive.
Yeah, so the Eighth Amendment, cruel and unusual punishment. So when you have $5,000 a day, I mean, that racks up. And the fine started on September 2nd, and they're already over $80,000. Another church in Santa Clara County is over $100,000 in fine.
Let's talk about criminal citations. So we know that there also, some counties are trying to go after people with criminal citations. For example, Pastor Parker Green was doing baptisms in Huntington Beach. Now, well, let's talk about the irony there. So he's got a house church, and they're doing these baptisms, and more information is getting out on social media. More people are coming out to Huntington Beach to worship and do baptisms at the ocean, where you've got the sea breeze coming. And what ends up happening is he gets criminally cited for a misdemeanor for an unlawful gathering, yet just a few weeks earlier, you had all the Black Lives Matter protests. You even had, before that, you had the Reopen California protests. And you have all of these people coming out, gathering right there in Huntington Beach. It was on the news. It's crazy. So now here he is. He's facing a criminal citation, misdemeanor with a fine up to $1,000, imprisonment up to 6 months. And he says, no, we're going to fight that. And so we're working with him, and we're going to be bringing a lawsuit against Huntington Beach as well. And so, there's also the ban on singing. All right? There's another order that says, hey, you can't sing anymore.
Yeah, that ban on singing is still there, even though a lot of churches can't do any indoor services. If the government grants you permission to do an indoor service, you can't sing worship songs.
So we filed a lawsuit there on behalf of Calvary Chapel, Higuera, Pastor Les Boa, Calvary Chapel, Fort Bragg, Pastor Kevin Green, River of Life up in Oroville with Pastor Scott Thompson. And these pastors are saying this is ridiculous. Yeah. And so that case, what's the status of that case right now?
So we filed a preliminary injunction asking the court in federal court to halt enforcement while we have this case and get discovery and go through the process, to halt enforcement of that worship ban because it's unconstitutional. And we have a hearing on that on October 16th. So if you can please be praying that the court grants that preliminary injunction and halts the enforcement of this ridiculous worship ban.
Let's talk about another restrictive thing. The list of attendees saying you cannot, if you're going to meet, you have to keep a list of attendees so that we can trace back your attendees.
Yeah, back to Santa Clara County, racking up those fines. They also, even when churches were allowed to meet indoors in June, statewide, they said, no, you have to meet outdoors. You have to limit that to 20 people. And you have to take the name, the contact information of each of those people, and be ready and willing to hand that contact list over to government officials. And again, the same time as all these protests, as you had county officials in Santa Clara advertising these protests on their social media, participating in these protests, yet they're telling churches only 20 people, only outdoors, and you better keep a list. I mean, what are we at Hitler's Germany? It's ridiculous. And especially as a former Muslim who, it's still, the death penalty is imposed on Christians who converted from Islam. And so to think that...
In the Middle East.
Right, yeah, in the Middle East. Thankfully not here yet. But to think that some people in that position in Santa Clara County would have to give their name and contact information to government officials. I mean, it's crazy. It's absolutely ridiculous. So we filed a lawsuit in June, and that lawsuit is pending. And
on a side note, I think on our YouTube channel, we also have Netta's personal testimony of a former Muslim coming to Jesus, and so you can go back and look at that as well. We're starting to build this YouTube channel. We'd love it if you guys subscribed and help support our efforts and our work. Also in San Diego County, Pastor Parker Green, he was doing baptisms at the beach. Guess what happened? The county of San Diego said, you need to keep a list. And these courageous pastors are saying, no, we're not going to do that.
Absolutely not.
I know that we're running out of time. I just wanted to mention, if anybody has quick questions, I am watching the chat. If there was a question or two we could answer before we wrap up.
I'll summarize some of the other things. The outdoor restrictions in Santa Clara County. Originally, they said you could only have 25 people meeting together at church.
Yeah, 20
outdoors.
No drive-ins too. They didn't allow drive-ins.
Social distancing and masks had to be worn. There's another church that we're working with out of Calvary Chapel. Excuse me, not Calvary Chapel. There's so many Calvary Chapels. La Habra Heights. The city of La Habra Heights is coming against the church Word of Flame.
Yeah.
They're meeting outdoors in the parking lot at their church. They are social distancing. They're doing everything and that they're supposed to be doing. And then a neighbor complains that they're too loud. And we have pictures that they're under the decibel levels, and the city manager's going after them and fining them, and they're doing everything they're supposed to be doing according to the orders. Parking lots, Calvary Chapel, Downey, good example. They come out and they say your cars are parked next to one another in the parking stalls. What? That's a violation? You can go to Costco and you can have all these cars parked right next to each other, no issues. But when you go to church, you have to have your cars separated by a parking stall, and that is in the guidance.
The guidance uses it as an example. So it says to reconfigure parking lots to limit congregation points and ensure proper separation. Example, closing every other spaces. So it doesn't order it, but then you have La Habra saying that you have to do that, or Downey saying that you have to do that. I mean, it's absolutely ridiculous, and especially when you can park next to each other anywhere else.
I'm gonna, Jen, if there are any questions, look at those, and I would just want to say real quickly that one of the things that has happened is we've had to hire 2 additional attorneys. One additional attorney is coming on board for advocates. We've made an offer to another attorney, and we need the help. We need the support, and I'll just be blunt. Neither Jen or I, as partners in the Tyler and Bursch firm, we don't get any compensation from as a salary for our work that we do here in the ministry side with Advocates of Faith and Freedom. And we do it, it's a labor of love, but we need support, frankly, because we have to raise funds to be able to support the infrastructure that we need to be able to take these cases on. We have a lot of times these cases, it's 11 o'clock at night and we have to have something filed, and we're working till midnight, and we've got our paralegal working late helping. And so this has been an incredible 5 to 6 months. Very labor intensive,
and it's just getting worse. I mean, with the criminal charges and these outrageous penalties, I personally thought, well, if we just stick with it, it'll get better. But it's not. It's getting worse. More and more churches are being fined, and the counties are now filing the lawsuit. So it's not even us actively going to find cases. It's these pastors that are in tough situations that didn't ask for this.
And I'll be honest, the only question that we've gotten so far is there anything else we can do besides pray, which really goes into this. We need to hire more. I think we could hire more right now if we were going to take every client that's calling us. We just are at limited capacity at some point, doing as much as we can. Yeah, but we need to hire another paralegal, which is the person in our office that files everything. Even our receptionist is overloaded. At this point, we are just bursting at the seams trying to handle everything. So
the phone calls coming in from the needs of churches,
as much as
schools,
we need donations. Just to be totally clear, we are Advocates as a nonprofit, but for us, what that means is we represent all these churches and private schools without charging them, and Advocates even covers the cost. So they're getting so much pressure on the other side that we're trying to do everything we can, but we're at a limited ability to do that right now. So the best thing that you can do, besides praying, which is huge, and we welcome that and we need it, and we have so many things going on, but also just donations. We really need to be able to support what is happening. And at this point, it's just, it seems unending. It's exhausting at points, but you just got to keep fighting, just like these pastors in the private schools are.
Yeah.
let's talk about, we'll wrap up here, and I just want to remind you that we are going to be doing this for the next 3 Wednesdays at 10 a.m., not 9 a.m. It'll be at 10 a.m. on Wednesdays. The next time we do this coming Wednesday, or a week from today, we'll be talking about reopening plans for ministries and what you guys should be doing, what you should be thinking about, schools, churches. We also I think it would probably be beneficial to talk about reopening plans for businesses as well, because we actually have a lot of businesses on the private side for what we're doing. And potential for COVID-19 liability. What happens if someone were to come in and claim that they got sick because they were at your place of business or your church or your school? The next Wednesday, we're going to be talking about the new landscape of unemployment and the FMLA. Jen, give a very brief synopsis of what we're talking about there.
That's just to help businesses, churches, private schools. Unemployment laws, both federally and within the state of California, have changed so significantly. And we just want to update you guys on that and the new leave that's come through the CARES Act and the FMLA, and how that applies, so that you guys can just do just have the knowledge to be able to apply that and feel confident in it, as the laws have changed so dramatically in those 2 areas. It's hard for us to keep up with it, but we want to give you guys as much information as we can about it.
And then the last Wednesday at 10 a.m., we'll be talking about the pros and cons of state and federal funding for private schools. I think we could touch on as well for generally ministries as well, churches, others who actually take on, maybe they have homeless ministries, transitional housing, that kind of stuff. It doesn't make sense to take funds. And that has been a big question for a lot under the CARES Act, under this emergency funding that was authorized by Congress to be put out via the Small Business Administration. So we'll talk about that. We'd appreciate if you would go and register online at faith-freedom.com/events. That is where there'll be more information on this series, Ministry Under Fire 2020. We'll have it there. Please register, sign up, share it, please. And as I said before, there are other videos on our channel that you can go in and you can watch. And please share it with your friends. Honestly, our ministry only survives because of the support that we get from all of you. And it's brutal. I don't like raising money. I've never been very good at it. But we need help. So please share this, subscribe. What do they say? Like us on Facebook.
Click the button wherever the button is.
Subscribe to YouTube, Twitter. I'm looking at our back team behind the camera. So Twitter and Instagram and
Parler.
And Parler.
Do we have Parler yet?
Yes.
We do have Parler.
We have Parler. So all of those platforms. And don't ask me how to use them, but that's it. So everybody, thank you for joining us again. Thank you for your support, and please be praying for all the work we've got going and we've got ahead of us. In the name of Jesus. Have a good
Thanks,
day.
everyone.